Hello there. I am Brian Walsh with Allegra Marketing, Print, and Mail. And I'm here with our LaTip Professional Networkers Group. And this is Lee Lerner. And Lee is going to talk with us today about protecting what you own, making sure that the state or government doesn't decide who gets what in the event that you pass on. Lee, can you tell us a little bit about yourself?
Sure. A little bit about myself. I was born in San Francisco, but I was raised in Northern Virginia, just outside Washington, D.C. I was a competitive swimmer growing up. Went to a small college back east, Wesleyan University. It's in Middletown, Connecticut. And then went to John Marshall Law School, which is now UIC's law school. In the intervening years, they was transferred, and I have my own firms, very small firms, just me and a partner, called Schmidt and Lerner LLC. We're in Elgin, but we practice in pretty much all of the collar counties and in Cook. We do estate planning. We do wills and trusts, that sort of thing. We used to do a few other things, but we've started to narrow our practice, and now we really do only estate planning.
Right. And one of the things that I know you breezed over there was, you said, hey, we're a small firm. And to some people, that may sound like a limitation. But one of the things that I've always found cool over the years of knowing you is that you will go to the person's house. People sometimes are, confined to their bed, confined to their house, or in an assisted living facility and things like that. Yeah. And in a sense, you guys are mobile. You go where they need you to be.
That's right. We certainly do that sort of thing for clients that have mobility issues, and it is sort of a sad fact of my job that I have had to visit people in the hospital occasionally in hospice. This sort of thing is necessary in order to get people who have the capacity to make a will and a trust. And to execute such documents, powers of attorney. Sometimes it's necessary to visit them and for us to travel to them. And we can do that because we're small. We can kind of turn on a dime where a larger firm sometimes can't.
Right. So yeah, don't think of that as a detriment when you say that. So yeah, for someone who doesn't know what a will, a trust, or a power of attorney is, how can you dumb it down and tell somebody what it is and why they need it?
Well, a will is essentially a statement to the public. It's going to become a court document after the testator, the person who makes the will, dies. It is a statement of your last wishes, where your property goes. You name a guardian for your children in a will if you have minor children. Things like that. You can set a few other terms and conditions, but it's a public statement. There are formalities that have to be observed in order for you to have a legal will. A couple of witnesses need to attest that you are of sound mind and memory. In the will. A couple of other legal formalities, but that's essentially a public statement. A trust is a private agreement. No court really needs to step in to determine if a trust is valid. It's an agreement between the person who owns property and creates the trust, called the grantor or the trustor or the settlor. There are a lot of names for it, but the person who makes the trust is one party. And the trustee, who you're giving the property to, is the other party. Oftentimes, in fact, in my case, it's usually the case where they're the same person. And you give that property to the trustee, and the trustee does not get to enjoy the benefit of whatever property you've given to the trustee. They just manage that property. They manage it for the benefit of the beneficiary or beneficiaries. Sometimes those beneficiaries are, in my case, it's often our clients are also the beneficiaries. But in your trust instrument, in the document itself, you name successor beneficiaries for when you're gone. And that means that the next owners, you named successor trustees for when you're gone. So the next owners of whatever property is in the trust, those are already known, and they're subject to this private agreement that doesn't really require a court supervision to determine validity. Um, it it bypasses. It's a way of bypassing. It's one way to bypass, maybe the main way to bypass probate. Um, so trusts are the way that we typically, but not always, but almost always, have our clients distribute their property after they're gone, rather than a will.
All right. So yeah, I mean, everyone knows what a will is. So I think, kind of to sum that up, the trust basically is especially valuable if you've got children and if you've got anything of value, because you don't want the state saying, what goes where. But the biggest thing is everybody who's ever been a parent knows that you're always worried about making sure your children are taken care of in the eventuality, and not even likelihood, I mean, you will eventually pass along, that when you die, that your kids are taken care of. And this is a way to do that. And then especially if they're minor kids, it's a way to make sure, when he was talking, big words, trustee, beneficiary, all that the person who's your trustee is the person that, like, if your kids are 8, you want somebody to manage all of your assets until they're 18 or 25 or whatever benchmark you establish, so that they just don't, burn through it and, not know what to do with it, and that they're legitimately taken care of. I mean, that's the big idea.
That's right. Imagine this: if in the absence of a will or a trust, the default setting is essentially children inherit whatever they're going to inherit at age 18. Now, I always ask clients, hey, do you remember back when you were 18, what would have happened if you had inherited a substantial amount of property? And most people, when they think about that, realize that, yeah, probably nothing good. So yeah, it's better for the grantor of a trust, or even if all you have is a will, it's better for the testator of a will to determine that age, to decide, to make a decision when the kids get everything, when do they inherit things outright. It's usually not going to be 18, but
right,
in the absence of any estate planning, it's going to be 18.
Right.
Yeah.
I had a friend who his dad left him him and his sister stuff, but the dad kept everything in control until they were in their 40s, and it was just ridiculous. The dad was still ruling from the grave. It was crazy. Sure. But so big question here: how long did you have to be a lawyer before you can say testator without laughing?
Well, it's a word that's commonly used in law school classes. So I don't think I actually had to be a lawyer yet. But I probably had to go through about a year and a half of law school before I could say it without at least smirking.
Right. All right. So you had mentioned when we talked this morning about who needs a trust, and you had zeroed in on some of the cases recently of children with special needs.
Yeah. If children with special needs do present some unique problems, a lot of times, with a trust at least, a lot of times a child who has special needs, if they have difficulty maintaining a work over the years, which isn't always the case, then it might be desirable for that child to receive public benefits. And in order to preserve public benefits yet still leave property to that child, you often want to have a supplemental needs trust, something that leaves all discretion for payment to the beneficiary, and to the trustee, not the beneficiary. So you find somebody that you trust, who knows your child and is going to keep tabs on that child's needs, And in that trusted person's discretion, they can spend on things like education, entertainment, whatever the child needs that is above and beyond those public benefits. But it's not typically intended to supplant or replace those public benefits. The point of a trust like that is really to preserve the child's eligibility for those public benefits. For when mom and dad are gone and can't really take care of the child anymore.
Mm,
So yeah, we do work like that quite often. Um, Another thing that we do regarding with special needs clients, a lot of times it's very important to have a power of attorney,
for sure.
particularly power of attorney in place for healthcare decisions. There's two powers of attorney essentially. One is for property decisions. One is for healthcare decisions. And the one for healthcare decisions. Um, when your minor children turn 18, they are technically independent of their parents and they make their own healthcare decisions. Sometimes mom or dad are there and doctors will talk to them, but it's not always so cut and dry. So it helps if you have a child with special needs who needs assistance making such decisions, informed decisions. Um, we sometimes will be able to have that child execute a power of attorney for health care
Mm,
that maybe gives one of the parents decision making capabilities starting right then.
right.
And that acts as almost like a HIPAA release where the child's physicians can speak to that parent, that
Right.
guardian. Yeah.
Well, it's not even just special needs. I mean, it's, typically, husbands and wives are kind of like grandfathered in. They're allowed to make each other's decisions in a hospital. But, if it's a mother, for instance, and you've got, three siblings and there's dispute over who's supposed to be in charge and what she might have wanted and what she told this one. If you have a power of attorney for healthcare, then mom has already decided that this
That's
sibling's
right.
the guy in charge.
That's
So
right.
that's the one to listen to. So it's
Yeah.
not just for special needs kids or anything like that. I mean, this is something that everybody should have.
Right. Oh, absolutely. Absolutely. Makes things if you've got say multiple children and you're in the hospital and the kids come to different conclusions about what mom would want or what
Hmm.
dad would want. There's really no resolution to that. The doctor's not going to be able to say, well, middle child, you seem to love mom or dad the most. We're going to go
Right.
with what you say. It doesn't
Hmm.
work that way. Instead, what happens is an impasse. It's all just come to a standstill and no decision gets made.
Hmm.
Not easily, not
Right.
easily. So yeah,
Hmm.
if a person contemplates that and puts it in writing, that makes things a whole lot easier. And kids usually, even grown kids, will usually respect mom or dad's decisions because they've put them in writing. They contemplated
Hmm.
these things. People
Right.
respect wills, people respect trusts, and people certainly
Hmm.
respect powers of attorney.
Right.
Yeah.
Yeah, and I don't know why they're not called different things, but the powers of attorney for healthcare is different than for financial because, like financial, like if mom's in the hospital for 11 months, like my mom was, you need to make sure that the house doesn't get taken away, and that's a whole different thing. That's the power of attorney for money.
Yes, that's
So,
that's right. Yeah, the power of attorney for property decisions like that it's not even necessarily for just useful for somebody who's in the hospital for a long, an extended stay. It could be these powers of attorney can be very helpful if somebody goes to the dentist for a routine procedure, let's say a root canal, and maybe the dentist prescribes some pain medication for the next week while the person recovers. And during that week, maybe the mortgage comes due. What happens? There's no one to pay. Um, let's say it's somebody who's single, right? Well, maybe that single person has named a friend the power of attorney for healthcare, or I'm sorry, the power of attorney for property. And so they come over and they now have access to that person's checkbook. They can write a check and they can send that off to the lender, and nobody's in default, and the person gets to keep their house. Uh, and as soon as as soon as the pain medications are gone in a week, and you're off the pain medications and back to your old self,
Mm-hmm.
you resume making your own decisions again.
Right.
So it's a very useful thing, and it's often temporary. It's not necessarily just an end of life, a document that's useful at for end of life
Mm-hmm.
decisions.
Right. So then this is a loaded question. I already know who should have all of this stuff. Who should have a power of attorney and trusts and all that.
I think almost everybody should have powers of attorney.
And I knew that would be your answer.
Yeah. Because those are documents that are very, very useful in unexpected situations. But you know what? Death is also an unexpected situation sometimes, and it's more unexpected, let's say, for people in their 20s, maybe 30s, who are outwardly healthy. But if you own real estate, that would trigger probate. So if you own a house in your own name, talk to a lawyer, get a trust, probably get a trust set up, and a will that will pour over your personal property to your trust at death. Figure out how to arrange things that way with a lawyer's help. And certainly anybody who's getting older, or who has some health issues that may be severe as time goes on, make those preparations. It's a lot less expensive, and it's a lot less hassle for your kids and for you to do it while you're alive and while you have capacity, than for your estate to go through probate.
Right.
Probate is very expensive. It's very time consuming, and it's public. So anybody who's really looking can figure out where, what a decedent, what somebody who's died, what they owned, and who inherited it. It's very costly to the estate. Whoever inherits is going to inherit less if it goes through probate.
Right.
Yeah.
All right, cool. Well, we're definitely, at time here, but I would say, in my opinion, the people who need it the most is anybody who owns property and anybody with kids. I mean, those are the two that you want to make sure that essentially that property goes down to your kids. I mean, that's the ultimate goal. But I do believe that everybody should have the power of attorney of healthcare, so that somebody, if you're in a car accident or something like that, somebody can make those decisions for you. So,
indeed.
All right. So, Lee, why don't you tell us a little bit about LATIP, since we're here as LATIP members? Just give us a brief, 15, 20-second thing on LATIP.
Well, LATIP's a networking group, and I've been a part of it for about 5 years now, I think it is. It's been very rewarding. I've really enjoyed being a part of, briefly one other group, but most of that time I've spent with this group in Hoffman Estates. It's a big group, and I think it's growing. And the camaraderie is terrific, and so are the business tips, the leads that we pass along to each other. It's a really good feeling when you are able to send something someone's way. Yeah.
All right. So I apparently had forgotten to turn this thing on, which had Lee's contact information. So that should have been running the whole time here, but there it is down there. So if you want more information about wills and trusts, I'm going to guess, Lee, what does it cost to talk to you to get an opinion?
To get an opinion doesn't cost anything. I'm happy to talk to anybody. Yeah, I'm happy to talk to anybody about it. You're never on the clock unless we tell you that you're going to be on the clock. Make a decision now if you want us to get the clock running. But with estate planning, we're not on the clock very often. We can usually determine a flat fee after I've talked to you and gotten some information. I can usually quote a flat fee, and we'll stick to that flat fee.
Yep. And people do like flat fees when it comes to lawyers because you know what
You know in
is
ahead.
coming.
Yes, and you have an opportunity to say yes or no. You don't.
Right.
You're not just being surprised with the bill in the mail.
Yep. So there you go. If you got any questions about any of the stuff we talked about, shoot an email to Lee. His contact information is at the bottom. If you want any information on LaTip, you can also shoot an email to Lee. We meet Tuesday mornings. We are currently still virtual, probably another month or so till we get back in person. But when we do meet in person, it is in Hoffman Estates on Tuesday mornings at 7 a.m. to 8:30 a.m. And let us know if you got any questions. Thank you so much.
All right. Thanks, Brian.